Evidence in the matters of applications by James Hugh Allister and others and Clifford Peeples for judicial review.
Lord Stevens will explain the court's judgment.
On this appeal, three issues are raised as to the lawfulness of the Northern Ireland Protocol, which formed part of the agreement between the United Kingdom and the European Union regarding the United Kingdom's exit from the EU. The 7 appellants, who included 2 previous First Ministers, David Trimble and Arlene Foster, brought proceedings challenging the lawfulness of the protocol. Their challenge was based on several grounds, including the 3 issues which I will now briefly summarize. In respect of the first ground of challenge, the appellants contend that the protocol is incompatible with Article 6 of the Acts of Union 1800. The Acts of Union are the acts which provided for the union of Great Britain and Ireland. Article 6 has 2 limbs, and the appellants contend that the protocol is incompatible with both of these limbs. The first limb, which can be termed the trade limb, in effect provides that the people of Ireland shall be on the same footing in respect of trade as the people of the rest of the United Kingdom. The appellants contend that the protocol is in breach of this limb, as the people of Northern Ireland are not on the same footing in respect of trade as the people of the rest of the United Kingdom, because, for example, the protocol requires the payment of a charge on goods coming to Northern Ireland from the rest of the United Kingdom if they may be moved into the EU over the land border between Northern Ireland and the Republic of Ireland. The second limb of Article 6, which can be termed the treaty limb, in effect provides that in all treaties with any foreign power, the people of Ireland shall be on the same footing in respect of trade as the people of the rest of the United Kingdom. The appellants contend that the treaty limb imposes a statutory restriction on the power of the government to make a treaty that does not provide for the people of Northern Ireland being on the same footing in respect of trade as the people of the rest of the United Kingdom. Accordingly, as the protocol is a treaty with the EU, and as it did not provide for the people of Northern Ireland being on the same footing in respect of trade as the people of the rest of the United Kingdom, it was said to have been made unlawfully. In respect to the second ground of challenge, the appellants rely on the Northern Ireland Act 1998, which declares the status of Northern Ireland as remaining a part of the United Kingdom and declares that Northern Ireland shall not cease to be a part of the United Kingdom without the consent of a majority of the people of Northern Ireland. The appellants contend that the protocol has brought about a substantial diminution in the status of Northern Ireland within the United Kingdom. Accordingly, the change to the status of Northern Ireland affected by the protocol was said to be unlawful, as it ought not to have taken place without the agreement of a majority voting for it in a poll in Northern Ireland pursuant to the Northern Ireland Act 1998. The appellant's third ground of challenge arises in the context that the continued application of Articles 5 to 10 of the Protocol require democratic consent in Northern Ireland by way of a vote in the Northern Ireland Assembly. Section 42 of the Northern Ireland Act 1998 provides that in relation to a matter which is to be voted on by the Assembly, if 30 members petition the Assembly expressing their concern about a matter, then the vote on that matter shall require cross-community support, as opposed to a simple majority vote in order to be passed. However, in enacting Section 8C of the European Union Withdrawal Act 2018, Parliament gave the Secretary of State power to make regulations to implement the protocol, provided that the regulations were compatible with the Northern Ireland Act 1998. In 2020, and exercising that power, the Secretary of State made regulations so that a vote on the continued application of Articles 5 to 10 of the Protocol can be passed by a simple majority, rather than requiring cross-community support. The appellants contend that the regulations are incompatible with Section 42 of the Northern Ireland Act 1998, so that the Secretary of State lacked the power to make them. All three of the appellants' challenges were dismissed in the High Court and by the Court of Appeal. The appellants now appeal to the Supreme Court, which unanimously dismisses their appeal for the reasons set out in a judgment given by me, with which the other justices agree. Prior to briefly summarising the reasons, I remind as to the intense and protracted parliamentary involvement in the arrangements for the withdrawal of the United Kingdom from the EU. In relation to the first ground of challenge under the trade limb of Article 6, the Protocol was incorporated into UK law by Section 7A of the European Union Withdrawal Act 2018. Section 7A stipulates that all enactments are to have effect subject to Section 7A. Consequently, if the Protocol conflicts with the trade limb of Article 6, then that article is modified to the extent that it conflicts with the Protocol. This aspect of the challenge is dismissed. In relation to the treaty limb of Article 6, it is correct that Parliament may restrict the government's power to make a treaty. However, Parliament may authorise the government to make a treaty, and it may do so by a later statute, even if there is a statutory restriction contained in earlier legislation. In this case, the government was authorised by the European Union Withdrawal Agreement Act 2020 to make the Protocol. This aspect of the challenge is dismissed. In relation to the second ground of challenge, the Supreme Court has previously held that Section 1 of the Northern Ireland Act 1998 does not regulate any change in the constitutional status of Northern Ireland, other than the right to determine whether to remain part of the United Kingdom or become part of a united Ireland. This aspect of the challenge is dismissed. In relation to the third ground of challenge, based on the inability of the Secretary of State to make regulations which are not compatible with the terms of Section 42 of the Northern Ireland Act 1998, the Court holds that prior to the regulations being made by the Secretary of State in 2020, Section 7A of the European Union Withdrawal Act 2018 had already modified Section 42 of the Northern Ireland Act 1998, so that at the time the 2020 regulations were made, they were compatible with Section 42 of the Northern Ireland Act as modified. Accordingly, the Secretary of State had the power to make the regulations, and this aspect of the challenge is dismissed. As I have indicated, the appeal is dismissed.